seat, please.
Just been left alone. Apparently it's a slow roll. All right, we've got. So ready to go?
Yes, Judge.
All right, we've got the defense, the defendants present, represented by counsel. We've got the witness back on the stand. Let's go ahead and get the panel.
Objection, Ms. Burton can come in when she's ready.
Just for you, so that's fine.
All right for the jury. Please be seated.
All right. Welcome back, ladies and gentlemen. State ready to proceed
Yes, Judge.
from the state.
Thank you, sir. Dr. Donoghue, during the autopsy, what personal items were found in Mr. Arbery's clothing, if any?
No personal items were found. No phone, no wallet, no weapons,
Nothing?
nothing.
And the projectiles that we've already talked about that were in State's Exhibits 342 and 343, they were sent internally within the Georgia Bureau of Investigation,
Right.
but to...
We haven't talked about all of the projectiles.
All right, let's go ahead and talk about all the projectiles.
Well, we found something that looked like black plastic fibers in the wound to the chest and axilla or armpit, and these were sent to the crime lab for identification, and it turned out to be botanical material, meaning some sort of plant, and that's just another thing. That's a very unusual thing to remove from a shotgun wound. And
All right, so let's talk about this. When you first were examining his body, this stuff that turned out to be botanical material, where was it?
well, it was within the wound.
The one up here in the
In
left
the-
armpit?
Yes.
Like how far up in the left armpit?
Well, I don't remember exactly, but it was not on the surface.
Okay, not on the surface. All right. In addition, when you first described it, what did you think it was?
I thought it was black plastic fibers because I could only presume that it came from a shotgun shell, and usually the things in the shotgun shell are either lead or plastic.
So you sent it off to the trace section,
Yes,
but they determined it was botanical material.
yes.
Do you have any opinion about how botanical material would have gotten up into the wound track on Mr. Arbery underneath his left armpit?
And it was black, so it leads me to believe that it somehow had gotten into the barrel of the shotgun, possibly why they were struggling, and maybe pointed it down into the ground and came up with this botanical material.
So we've talked about the botanical material and the pellets that we are looking at in those two exhibits sent off to Brian Leopard.
That's correct.
Now, here's the thing. Once Mr. Arbery had been shot in the torso right here, how in the world did he keep moving?
Well, this is what is called the flight or fight reaction, and when you run into a situation that is stressful or that you're afraid of, or is going to cause anxiety, your body will, the amygdala in the brain will correlate a flight or fight response. So it stimulates the adrenal glands to secrete adrenaline and noradrenaline and cortisol. And this has the effect of raising your heart rate, raising your blood pressure, dilating your pupils, even your acuity for hearing improves. It also shuts down the blood supply to the bowel or the gut, so that more blood can go to the muscles. And this prepares you either to run or to fight.
Okay. So, if Mr. Arbery had been under a very stressful situation for 5 minutes, okay, and we're talking fight or flight takes place, has he already got that adrenaline going in his system at that point?
He would, as soon as he realized that there was a threatening situation, that response would start.
Okay. And flight, meaning I got to run away.
Right.
What happens when you can't run away anymore?
Well,
I'm going to object. Beyond this witness's expertise, the area in which he's been qualified, and it's asking for speculation.
Lay foundation. It's sustained unless there's a foundation.
Do you have the expertise to address that particular issue of why someone who can no longer flee or run away would turn and fight?
well, it's
Objection. That was not his testimony, Your Honor. His testimony was after the first shot, what would have allowed his body to continue to move. What Ms. Donoghue is now asking about is whether or not how he reacted before the first shot, and that's not a proper area for inquiry with this witness.
I'd sustain the objection asking for a foundation. I understand you were trying to lay a foundation.
That's what I was trying to
Depends
do.
on the foundation. See what his expertise and knowledge is.
And that's what I'm just going to ask. Doctor, do you have the expertise and knowledge based on all your years as a medical examiner, forensic pathologist, to address fight or flight responses?
Well, it's the fight or flight response. So after you could no longer flee, you might fight.
Now, anatomically, when we're talking about having been shot right here in the torso, okay, did those pellets hit his or pierce his heart at all?
They did not pierce his heart.
Okay, so the heart's still beating.
The heart's still beating.
What did they pierce within his torso?
Well, they got the fifth right, the anterior. Well, first of all, they got the lower portion of the sternum, the breastbone. They've got the anterior fifth right rib, the fifth right intercostal space. That's the space between the fifth and sixth ribs. It got the anterior sixth right rib. It got the right middle lobe of the lung, the right lower lobe of the lung, and then it got the lateral 6th through 10th right ribs and the corresponding 6th through 9th intercostal spaces.
So did it break ribs 5 through 10?
Yes.
All right, so all the ribs over here got broken, 5 through 10.
Yeah. Yes.
What happens when you break all of these ribs over on the right lateral side?
Well, it becomes difficult and painful to breathe, and also there is the intercostal arteries run on the lower edge of those ribs, so you would bleed into the chest cavity.
All right, so when we see Mr. Arbery with all the blood underneath him at the crime scene, was that due to that blood into the basically chest cavity?
Yes.
All right. So the gunshot wound to this torso, was that a fatal gunshot wound? If he had never gotten this one under the arm, would that one in the middle of his torso have killed him?
Yes.
Was there anything EMS or the officers could have done on the scene to save his life from the torso shot?
Well, they could put an occlusive dressing on the large defect, but you would still have the exit defects in the back of the chest. And they couldn't do anything about the bleeding as long as the heart was beating.
So would he have just, in other words, is there anything they could have done on scene to save his life?
No.
And then I think lastly we have State's Exhibit 413. So I'm going to show you what's been marked as State's Exhibit 413. I'm just going to show you the exterior of the bag. Prior to coming in here today, were you able to examine all of the items collected from Mr. Arbery, including his clothing and the shoes?
Yes, I was.
All right, and is what's contained in State's 413 the shoes that you collected from Mr. Arbery?
Yes.
At this time, the State would tender into evidence State 413.
No objection.
Judge, I object on relevance grounds. What's the relevance of these tennis shoes?
The relevance of these tennis shoes is to demonstrate that he wasn't.
Objection, Your Honor, if this is going to be a speaking response to this objection, we would ask that it be done outside the presence of the jury. It's an issue the court's been very clear about.
Okay, ladies and gentlemen, if you could just step into the jury room for just a moment.
All right for the jury. Please be seated.
Ms. Donoghue.
The State does not wish to put in a large amount of his clothing due to the contamination situation. So we're not going to put in the belt and the pants and the T-shirt or anything like that. They have photos of them, of those items. The shoes in the State's opinion are relevant because the State's argument is going to be simple, that Mr. Arbery, based on the evidence, when he would visit 220 Satilla Drive for a few moments and go in, would take off running into the neighborhood. That's the evidence. So this, of course, shows that that particular day he had running shoes on. This is what he was wearing. He walked up to the residence and then he ran away. And these are just the shoes that he was wearing. So it's evidence of what he had on that particular day, his running shoes.
It's a backdoor way of entering into evidence what the court has already ruled so far the State can't do, which is to argue that Mr. Arbery is a jogger in the neighborhood. There is no relevance of the shoes in and of themselves. It didn't inform this doctor of anything he had to do in performing his autopsy. If the State wants to argue that Mr. Arbery is a jogger based on the fact that he's wearing tennis shoes, then we should have the right to provide, again, that alternative explanation for why he's running.
I join in with Mr. Rubin's objection for all of those reasons and reiterate now for the third time, the shoes and their condition and the type of shoes they are is just another way of saying to the jury, look how much he runs. He runs all the time. Therefore, that's what he was doing on 2/23/20 when they encountered him in Satilla Shores. If that's the relevance of the shoes, the State doesn't set it quite that way, but that's the only relevance of them it could be. It opens the door to us to say, well, then let's give you some alternative views for why he would be running in Satilla Shores on 2/23/20. What we had an argument about the other day and the court made a ruling. This isn't the same type of evidence the state's trying to introduce now.
Based on the state's explanation of why they're tendering this exhibit, we will join in the objection of the McMichael defendants. I'm very concerned about these shoes going out to the jury. My understanding, these are in fact Max Air Nikes. Most but not all of these brand of running shoes, these athletic shoes, are running shoes. Some of those branded shoes are shoes for other events, such as basketball. Now we're going to be sending back these shoes without any expert testimony or other testimony establishing what kind of shoe they are for the uninformed and unguided speculation of the jury as to whether these are in fact running shoes or not. There's been no testimony, and unless there's something in the discovery I didn't see, there's been nothing presented as to the tread or the composition of these shoes to establish if they're running shoes. We're just going to send them back to the jury and ask them to speculate about it. That's highly improper. And I agree with the McMichaels. It's going to open the door to all kinds of testimony that I thought the state didn't want to get into. I object at this point to the tender of these shoes.
I won't tender the shoes. That's fine.
Okay. If I understand, the tender's withdrawn. The tender's withdrawn then?
Yeah, I'll withdraw it. That's fine, Your Honor.
All right, let's go get the panel.
Should we inquire, though, whether the photograph of the shoes that was used in the opening statement, and apparently has been introduced somewhere along the way here, hasn't already done the same thing the actual shoes have done, so that the state will now think, well, we can go ahead and argue in closing argument by showing the photo of the shoes what they argued in an opening statement, and that is he's an avid jogger. Again, we don't dispute that he was an avid jogger. We just dispute whether we can now offer an alternative explanation for his running on a particular day and place. So if withdrawing them now still leaves the state open to making that argument in closing, if they're indicating that's what they plan to do, then the door's open. And we should be allowed to give alternate explanations for his running on 2/23/20.
As I understand it, the state has withdrawn the tender of these shoes, so that's not an issue. As far as opening the door, whatever evidence is in, and as far as the court is concerned, that door has not been opened. So let's go ahead and get the panel.
Yeah, if I may just to clarify then, if we don't know whether that's the argument in closing until they get to the closing and the evidence has been closed, then we've lost our opportunity to provide an alternate explanation for what I anticipate will be an argument by the state to the jury.
No, the door has not been opened. If that's an argument that's made simply based on a pair of shoes that Mr. Arbery was wearing, that's what he was wearing at the time in the neighborhood. But there's other evidence that can be argued. So, no, it has not opened the door to matters that have not come into this point.
May I inquire, though, Your Honor, because I'm really trying to follow with you and perfect the record, not arguing with the court. The shoes, though, are of particular evidentiary concern to the state and obviously, therefore, to the defense. His belt is of no concern. His shorts are of no concern. The shirt's value is minimal. It just shows where he was shot. His underwear is of no concern. The shoes, though, are critical, as I see it, to the state's argument that they've set up from opening statement forward. So I'm not sure what the court's saying. Other evidence that has been introduced has to do with the evidentiary value of the shoes. And, of course, the shoes themselves now are being withdrawn, but the photo's in, the argument's been laid. I think the door's been opened already. That's our position, Your Honor.
Honorable, the court has specifically said, based on what I understand of the evidence at this point, the door has not been opened.
A related point, Your Honor. Under Georgia law, the state has the opportunity to open and close. In this part of the state, prosecutors typically waive the opening portion. I think Ms. Duncasey has indicated that she's not going to waive the opening portion. My concern is the court has discretion over closing arguments, and I would ask the court to require the state, if they're going to address this running shoe argument in their closing, that they do it in the first half or first portion of their closing, so that defense counsel can hear the state's argument for the first time before we have to respond. Otherwise, the state's going to come in after everybody's rested and throw this argument out there, and we're not going to have any options other than to try and object to it. And it's a notice issue, not just a fairness issue. Not just whether it's based on the evidence, it's a due process fairness issue for the state to come in after all the defendants already rested in the trial and put forth some novel argument, some clever argument based on these photographs with respect to these running shoes. The court has the discretion to require that argument, if it's going to be made prior to defense counsel having to give their closing statements, unless the court's planning to allow us to reopen and re-argue the case after the state is done.
Why don't we reach this at some point that's more relevant to where we are in the trial? I'd like to get the jury back in to finish this witness's testimony. The state has withdrawn its tender. If you want to raise that matter later, you're welcome to do so, and we can address that. Let's go get the panel.
Please be seated.
Welcome back, ladies and gentlemen. I understand the state is withdrawing the tender.
Yes, sir.
All right. Ms. Davis.
Dr. Donoghue, what was Ahmaud Arbery's cause of death?
It's my opinion that Ahmaud Arbery died of multiple shotgun wounds.
I'll pass witness.
Morning, Doctor.
Good morning.
Dr. Donoghue, my name is Bob Rubin. We spoke on the phone way back in March of 2021. I don't know if you recall.
I recall.
Okay. And then I think we spoke just about a month ago in October, shortly before trial began. Do you recall that as well?
I don't recall that.
You remember being on a phone call with Ms. Hogue in
Yeah,
October?
yes, I do.
You may not have known, but I was on that call too.
Okay, all right.
Thank you for being here today. I want to ask you a couple questions just about your background. You were the medical examiner and then chief medical examiner in Cook County, Illinois.
That's correct.
And during that time, is it fair to say, Dr. Donoghue, that you saw dozens, maybe hundreds of cases, maybe more than that, of gunshot wounds?
Yes, that would be fair.
And of those gunshot wounds, the subcategory of shotgun wounds, would it be fair to say you saw at least dozens of those?
Well, the shotgun wounds were less frequent.
So less than the gunshot wounds total, but still a substantial number?
Yes.
Okay. And over the years, it's your, and even in your time with the GBI, it's your practice to, in examining a body before autopsy, is to start kind of from the outward and work your way in.
That's correct.
Okay. In this case, going back to February 24th, 2020, Mr. Arbery was brought into your autopsy room, correct?
Yes.
Photographs of the outside of his body were taken by staff.
Yes.
And you have a death investigator working for you.
Yes.
And her name is Shannon Walden.
Yes.
Okay. Does Ms. Walden still work with you?
Yes.
Okay. And you have other staff as well that help you with the autopsy process.
That is correct.
Okay. When Mr. Arbery came in, did you have some information about what happened in Satilla Shores on February 23rd?
Yes, I did.
Okay. And tell us who provided you the information.
Well, Alexis Brown, who is a death investigation specialist, was contacted by Deputy Coroner Christy Rozier of Glynn County.
So Ms. Rozier from Glynn County Coroner's Office gave information to Ms. Brown, who works for you,
That is correct.
and passed that on to you.
We wrote a report, yes.
Ms. Brown wrote a report.
Yes.
Okay. And at that time, were you aware that there was a video of the shooting in Satilla Shores?
I was not.
Okay. When was the first time you were made aware of that video?
I don't recall. It was certainly after I wrote the report.
It was after you wrote the report. Of course, the video itself became public in April of 2020.
Well, that's probably when I heard about it, yes.
When it hit the news, did you connect it to Mr. Arbery's case?
Well, I would have connected it to Mr. Arbery's case, yes.
Okay. So that was May or June, would that be fair to say, of 2020?
Well, I'll have to go with you because I have no recollection exactly when it was.
Okay. Did Ms. Brown, Ms. Walden, or you say at that point, oh my gosh, we have a video of the shooting, let's go back because we could amend our report?
No, I don't think anybody said that.
Okay. Was there anything preventing you from obtaining a copy of the video from Glynn County Police or the GBI so that you could look at the video and compare it to your report to see if you did want to be more accurate in your analysis of the case?
Well, there was nothing preventing us from doing it, but I don't think we saw any reason to do it.
Okay. No reason, I guess, because your report was your report.
Well, I don't understand that question.
Well, you changed your opinion on a couple matters after viewing the video.
Yes.
So when you say there was no reason to look at it in May, June, July, August, September, etc., I'm not sure I understand your answer.
Well, I can tell you when I first saw the video, it wasn't broken down into individual frames, and it was really difficult to tell exactly what was going on. It was so fast.
Okay. Did you ever contact the GBI and say, hey guys, when you slow this down, or when you do break it down or get it enhanced, call me up because I'd love to look at that?
No, I never said that.
So on February 24th, you did your autopsy and you examined the shirt as we saw in the photographs. And then the shirt was sent to the crime lab, was it not?
Yes.
To be examined by crime scene analysts, by GBI crime lab technicians like Brian Leopard.
Well, yes.
You knew at the time you did the autopsy that Mr. Arbery was wearing the shirt, right?
Yes.
And you knew that since you were examining shotgun shots, that shirt came between the muzzle of the gun and his skin.
Yes.
Okay. Did you then at that point request Mr. Leopard to examine the shirt to see what he found in the shirt?
I did not.
Wouldn't that be standard procedure when there's an article of clothing between a shotgun or a gunshot and the skin of the individual?
No, it is not standard procedure.
Did you later learn that Mr. Leopard, in fact, did an examination of the shirt and came to a different conclusion than you did in terms of muzzle to target distance?
I did.
Okay. When did you first become aware of Mr. Leopard's conclusion that it was a contact or near contact wound?
I believe on September 23rd of this year.
Of 2021?
Yes.
So if he testified yesterday that he came to his conclusion, I think in June of 2021,
Yes,
he didn't call you.
that's correct.
The GBI didn't call you.
That's correct.
The Cobb County District Attorney's Office didn't call you
That is also correct.
to see if it would make any difference. It was Laura Hogue who contacted you to see if Mr. Leopard's conclusions would impact your analysis.
Well, no, I found this out on the 23rd. Laura Hogue contacted me on the 29th
Of September.
of September, yes.
Okay. Prior to, well, you found out from who?
Well, we had a pretrial meeting with the prosecutor, and Brian Leopard was there.
Okay, so that's the first time, September of this year, a couple months ago, is the first time you understood.
That's correct.
Okay. For everybody's concern, I'm not going to touch the shotgun in evidence, but I have a very poor simulation, just a piece of tubing.
Okay.
Your initial analysis of target to muzzle distance was 3 to 4 feet,
That's correct.
based on the wounds that you saw.
That's correct.
And 3 to 4 feet would be approximately this distance.
From where to where?
Well, I'm sorry, from here to the front of the bench. That look about right?
Looks a little long. Yeah, probably about that.
Does that look
Yeah.
about right?
Yes.
That's a big difference in analyzing a case from inches.
Yes.
Okay. When you examined Mr. Arbery, I think you testified that he was 5'10", 164 pounds, muscular.
Yes.
And you again, you may not have testified it, but you found in your examination he had tattoos along both arms. Is that
Yes.
correct?
Yes.
Did you analyze that tattoos at all and provide that information to law enforcement?
I did not. We photographed the tattoos, though.
And provided your photographs to law enforcement?
Yes.
Okay. He was wearing tan cargo shorts.
Yes.
He had on a camouflage bandana, right?
Around his neck, yes.
And a tan bandana.
Yes.
Also around his neck or somewhere
Yeah,
else?
around his neck.
So 2 bandanas. In examining his body, did you note that his toenails were very long and dirty?
I did.
You've testified to the 3 wounds that you found. Center
Yeah.
chest, left upper shoulder armpit area,
Yes.
and I know these are not the technical terms that you
No, those are fine.
and then the right wrist going from thumb to pinky graze along the right hand.
Yes.
Am I saying that right? I think you used the term radial to ulnar,
Radial to ulnar or thumb to little finger.
thumb to little finger. And would it be accurate to say that the path was along that way, or are you saying it was
No,
this way?
the path was it was kind of triangular, and it was the axis would be perpendicular to the long axis of the arm.
Could you show that again for the jury?
Well, we have a picture of it. I think that would be the best way to show it.
You want me to go through 1,095 pictures?
And I don't. Maybe I could do it.
Well, let me see if I can easily access the photo. Oh, it's right on top.
Okay, that's the picture.
So is it going like that?
Well, I think the picture speaks for itself.
Well, I'm asking you if
Well-
you could help us here.
Why don't you let him sit down and use a pen to show what he would describe?
No problem with that at all. Dr. Donoghue, can you step down and maybe help us?
Step down.
If you sit down, the document's right there in the document camera.
Okay.
Let me get this door for you.
Thank you.
State's Exhibit 12.
Okay. State's Exhibit 12 shows the wrist and the thumb.
You're gonna do me a favor and just put your pen so we can see it on the board.
Okay, there it is.
Okay.
And that is going from the thumb side to the little finger side.
Okay. And I guess my question is that like straight across,
It's
or is it at an angle?
It looks like it's a triangular wound. It's expanding as it goes farther.
Okay. And so what does that tell you about that wound?
Well, it tells you that it probably started on this side and was shot dispersed.
Okay. Okay. Thank you. You knew at the time of your report in April that the gunshot wounds on Mr. Arbery's body were the result of a struggle over a shotgun.
Yes.
Okay, and you knew that from the information gathered by, I think you said, Alexis Brown.
Let me just check on that. Well, it says an altercation that resulted in him being shot multiple times.
Well, it says a struggle over the shotgun in your report, does it not?
In my report.
On page page 5 of your report, didn't you state that the 25-year-old black male Ahmaud Arbery died of multiple shotgun wounds sustained during a struggle for a shotgun?
Yes.
Okay. So you were aware at the time you wrote the report that there was a struggle over a gun?
Yes.
You were aware, were you not, that Mr. Arbery in fact had his hand on the shotgun?
Well, if there was a struggle, I guess he did. I didn't have any video of the incident.
Okay. And the video wouldn't change that. You saw, in fact, in the video and in the frame-by-frame, a struggle over the gun.
Right.
You saw in the frame-by-frame that Mr. Arbery had his hand on the shotgun, correct?
Yes.
You saw in the video and in the frame-by-frame that even with the wound to the wrist, Mr. Arbery was able to swing punches and hit Travis McMichael.
Yes.
Nothing about the radial artery or the wound that we saw in Exhibit 12.
Ulnar artery.
What did I say? Radial artery, not radial artery. Ulnar artery.
Yes.
Okay. Nothing about that wound, the blood spurting, or any other damage to the tissue prevented Mr. Arbery from holding the gun with one hand and swinging and hitting Mr. McMichael with the other hand.
That's correct.
Of course, as the medical examiner, it's not your concern of what led up to that moment.
I'm not sure I understand that question.
You don't know what happened at Larry English's house?
No.
You don't care what happened at Larry English's house?
Well, I don't know that I don't care.
Because you don't know what you don't know?
Yeah.
Okay. You didn't ask about what happened at Larry English's house. No one reported it to you.
Well, there was television coverage of that.
I mean officially.
Oh, no, officially, no.
Okay. It wouldn't change your opinions in this case. You're looking at the body and reporting as a scientist what you see on the body.
That's correct.
Okay. Did you ever reconcile with Brian Leopard why you came to the conclusion that the chest wound that you examined, that the target to muzzle distance of the chest wound, in your opinion, is from 20 to 3 inches, and Mr. Leopard's opinion is it's either a contact or near contact, which he describes as an inch. Did you ever reconcile that?
Well,
with him?
I told him that I thought that he was shot through the wrist in front of the chest. And no, I guess we never reconciled that. Although, I felt because we kind of agreed because we both said it could be a close contact wound.
So the one area of agreement that you have in your muzzle to target distance is you both agree it's at some point it could be within an inch to 3.
It's possible, yes.
Okay.
I said 3 inches. Yeah.
You said 3,
Yeah,
but he testified to 1, and you disagree with that opinion.
Well, I don't disagree with it, but my opinion is 3.
Okay.
Because you have the wrist there. You can't get any closer.
So let's talk about that for a second.
Okay.
You were asked by the GBI back in May if you could determine the sequence of shots.
Yes.
And through Shannon Walden, you reported to Lawrence Kelly, that's his right name, Agent Kelly, that you could not determine the sequence of shots, right?
That's correct.
Okay. You were asked actually by the FBI in July of 2020 if you had an opinion about the sequence of shots, right?
Yes.
And you reported to the FBI that no, you don't have an opinion as to sequence of shots, right?
Yes.
Okay. Now, by July of 2020, certainly you were aware there was a video.
Yes.
Did you say to the FBI, you guys, if you want an opinion, bring me the video, and I'll look at it for you?
Well, that's not how it runs. Usually there's a prosecutor who will contact us and we'll talk about the case, and at that time it might come up, but we don't continue to work on these cases if there's nothing happening.
Okay, but you were being contacted now by 2 investigative agencies and asked your opinion. You were aware they wanted your opinion about this.
Well, I'm not sure why they wanted my opinion about it. In fact, the people should know generally we do not have opinions about the order of the shots.
It actually is something that's fraught with danger for a medical examiner to give an opinion about the order of shots.
The medical examiner just can't do that. I don't know how he could do it.
Right.
This is an exceptional circumstance where there's a video.
Right. And that's what you told the FBI. We don't do that. That's not something our office does.
Correct.
But once you were provided the video, you now, as you've testified, do have an opinion about the order of shots.
Yes.
Okay. And it's based on your analysis of the frame-by-frame photographs from the video.
That is correct.
Okay. Ms. Donoghue posed to you a couple hypotheticals of how Mr. Arbery's wounds were in fact inflicted, right? One question was, could the wound to the wrist, which you've described now for the jury and shown them, have occurred because Mr. Arbery swiped the gun and somehow the shot was from his thumb to his pinky?
Well, that's not exactly what she asked me. I don't. And I think I answered that question with a no, didn't
I think you did.
I? Okay.
Okay. Another alternative explanation, would you agree, is that Mr. Arbery in fact grabbed the gun, and when the gun was pulled back and fired, it could have caused the injury.
That could have happened, yes.
And that is consistent with...
The injury is to the wrist, though.
Would have been more like that?
Yes.
Okay. And that's consistent with the video and the frame-by-frame analysis that you've seen in this case?
Well, I don't know. I couldn't see where that happened. It happened in front of the truck. So,
right. So you're doing your best to give opinions, but you really couldn't see.
Well, I know the location of the wound, and I know that it bled.
So when you do see the wound to the wrist, it's already to the left of the truck as we're facing.
Well, I don't know that I ever. All I see is the blood coming from the wound at the wrist.
Right, and I mean that's what informed you was the blood.
Right.
The arterial spurt.
Yes.
Okay. My question is it consistent with the wrist wound for Mr. Arbery to have grabbed the gun and the gun been pulled back by Mr. McMichael when it was fired?
That's possible.
That would have explained both the injury to the wrist and the injury, the close contact or near contact or 3-inch wound or
Yeah.
distance.
Allowed
that you-
room for the wrist, and we're
Right.
agreed.
A couple inches.
Yeah.
Okay.
Mr. Rick, was all the jury able to see that? Do you know?
You testified today. By the way, I don't know, from looking at the video in your analysis for this case, did you determine how many times Mr. Arbery punched Mr. McMichael?
I did not.
Okay. You didn't count it?
I did not.
Okay. In testifying about Mr. Arbery's actions after being shot, let me back up a second. You watched the video and saw him, despite having a shotgun wound to the chest, which was fatal,
The chest and the wrist, yeah.
and the wrist, he's still able to push Mr. McMichael through the truck off screen from the video,
Yes.
some 10 feet or more from what you can see on the video.
Yes.
Still able to punch and grab the gun at the same time he's punching from the video.
Yes.
And you described the adrenaline that Mr. Arbery could have had, which could explain why he's able to continue doing that.
Yes.
And I think you described it as a fight or flight response.
That is correct.
Now, again, you don't know what preceded what you saw on the video, right? In terms of what Mr. Arbery had been doing beforehand.
Well, there's a lead into the video. He was obviously running.
He was running towards Mr. McMichael.
He was running toward the truck.
Well, did you see Mr. McMichael in the video?
Yes.
Okay. He's actually running towards Mr. McMichael, is he not?
Well, I don't know that he was running toward Mr. McMichael. He went around the right side of the truck.
Went around the right side of the truck and then cut left.
Yes, he did.
Okay. And did you see to the right of Mr. Arbery a yard, a neighborhood?
Yes.
Okay. So you're not saying in looking at the video that he couldn't have continued to run, right?
Objection, speculation, and by the way, I think the jury can go ahead and see and determine what Mr. Arbery could or could not have done.
I think Dr. Donoghue's testimony was in describing fight or flight that after he could no longer flee, he could fight. And I'm asking him, is there any evidence that Mr. Arbery could no longer flee?
So you're asking what that's based upon?
What his testimony was based
Good.
on. Okay.
What, could you repeat the question?
Sure. I believe you testified on direct examination that someone in the fight or flight mode, when they can no longer flee, can fight.
They can.
Okay.
Yes.
You didn't see any evidence that Mr. Arbery could no longer flee, right?
Well, no, I didn't.
Okay. You examined his body. He was a muscular 25-year-old man, right?
Yes.
Looked to be in good shape from the autopsy, physical shape.
Yes.
Okay. And so there was nothing physically preventing him from continuing to run, right?
No.
And nothing, in fact, from the video you examined from the neighborhood preventing him from running.
That's correct.
Okay. You described the basis for the adrenaline dump and cortisol running through his veins as caused by stress.
Or
right?
fear.
Or fear,
Yes.
anger.
Anger too. Yes.
Okay. And you have no idea what he was afraid of at that point in time, correct?
Well, there's a man holding a shotgun out there.
Right. So could have been afraid of being shot.
And there was a man following him in a pickup truck.
Okay. Could have been afraid of being caught.
Caught. I don't understand.
Do you know if Mr. Arbery was afraid of being caught?
I don't.
Right. You don't know what you don't know.
Well, yes. I don't know what I don't know.
Okay. You testified that there was nothing that could be done on scene that could save Mr. Arbery's life. Is that correct?
I think that's correct, yes.
The phrase you used when you talked to us in March is he was essentially dead before he hit the ground.
Yes.
Excuse me 1 minute. Thank you, Dr. That's all I have, Your Honor.
Any additional questions from the defendants?
Not from Mr. McMichael.
Not from Mr. Bryan.
Any redirect from the state?
Just a moment, Your Honor. Nothing further from the state. Of course, we reserve the right to recall the doctor.
Thank you, Doctor. You can go ahead and step down. You are subject to recall.
Thank you, Your Honor.
Thank you. All right, ladies and gentlemen, it is noon. Let's go ahead and break for lunch. We'll break until 1 o'clock, and then we'll continue with the evidence at that time. Thank you.
All right for the jury. Please see it.
Anything in the state before recess?
No, Your Honor.
From Travis McMichael.
No, Your Honor.
From Greg McMichael.
Very well.
From Mr. Bryan.
There you are.
All right, in recess then until 1 o'clock. Thank you.